Hello, and welcome to another episode of Law and Sarasota. I'm your host, Adam Tebrugge. Today, I'm joined by an outstanding land use attorney who's going to help us understand the issues surrounding code enforcement. Robert Lincoln, welcome to the program.
Thank you for having me, Adam.
You know, Robert, I've had a lot of friends and acquaintances on this show over the years, but I've known you the longest. We first met in 1979 at New College of Florida, right here in Sarasota.
That's right. We had classes together, and you were my brother's roommate for a while.
Robert, I went on to Florida State University College of Law and then came immediately back here to this community. I've been practicing since 1985 here in Sarasota. What about you? What was your journey to the law after New College?
Well, it was a little more circuitous than yours. After I got it out of New College, I'd been doing political work and some campaigns. I'd also gotten into technology. I spent some time in Sarasota installing and selling computers, installed some of the first networks here in town, was doing some consulting, and then in about 1985, I decided to go sailing for a couple of years. My parents were down in the Virgin Islands and had a yacht management company down there. So I did that for a while, came back in 1987 and went to work for the county planning department and started working on my graduate degree. Florida State was doing an extension program up USF in Tampa, and I did that part-time for a while, and then moved to Tallahassee and completed my master's program up there full-time. And when I finished that, and that was 1990, I decided to go to law school at that point. So went to law school at Florida State, graduated in 1993, did a lot of work while I was in Tallahassee on growth management policy. It was my interest from being at the planning department here. And when I got out, I spent a year at a think tank and policy institute that was attached to Florida Atlantic University. And then after that, I went up to Michigan State University and was up there for about a year and a half and was part of the faculty in the planning department up there. I came back to Sarasota after that, really did not like Michigan winters, and I worked in the technology business again for about 8 years doing marketing and things. But starting in about 2002, I realized that if I really wanted to do some tech work, I was going to have to move to New York or the Bay Area. I didn't want to do that, so I fired up my law license again and started practicing law and got back into land use and zoning. And I've been, since 2004, I've been with Icard Merrill here in Sarasota, who's one of the oldest firms in town and has one of the biggest and deepest real estate and land use departments.
Well, Robert, I think all of your experiences have served you well over the course of your career because you're now widely recognized as a leading land use attorney. You teach on the subject, and you are involved in a number of different issues here in the community.
I have been over years, whether it's been testifying about ordinances to be made, and I actually have a regional and statewide practice teaching, and a lot of my work now is in litigation. For the last few years, I've been litigating issues all over the state. I think my biggest regional, local thing was the Longboat Key Club litigation, where I represented the property owners out there.
Well, Robert, I brought you on the program today because I wanted to discuss the issue of code enforcement. Code enforcement is one of those legal matters that can touch almost any citizen who lives in Sarasota County, whether you live in one of the municipalities like Venice, Northport, or the city of Sarasota, or even if you live out in the county. For instance, a couple of years ago, I came home and on my front door there was a notice from the city of Sarasota Code Enforcement Department. So other than taking the notice off of my front door, what's some good strategies when you first get contacted by your code enforcement department? And before that, I guess, what is this code that we're talking about?
Well, the code is actually any ordinance adopted by a local government that provides any kind of standards. Mostly we think about zoning and building codes being enforced through code enforcement, but really a local government can enforce any of its ordinances through code enforcement. And code enforcement is a civil option. It means that they can enforce their codes against citizens, residents, property owners through a civil means, an administrative kind of hearing, rather than having to take you to court in front of a judge. So the essence of the code enforcement systems, which will vary somewhat from jurisdiction to jurisdiction, is that you're going to appear before either a code enforcement special magistrate or a code enforcement board. And again, there's variations, but the important thing to remember is that board has the authority, or that special master has the authority, to fine you. And those fines can be substantial. They can be for up to $500 a day for violations that continue on for a while. And in some cases, we see people who have $10,000, $20,000, even $50,000 code enforcement fines levied against their property. And those fines become a lien, which means that if it's your homestead, they can't force you to sell the house. They can't foreclose that lien. But if it's not a homestead, they can foreclose it, take you to court, have the property sold to pay the lien off. And if it is your homestead, the lien remains until you sell the property, at which point, unless the money goes immediately into another homestead, the government may be able to get at it.
Well, Robert, I don't want any of those things to happen to me. I can't pay those fines. But this code, if I live in the city of Sarasota and I want to find what's in my code, where would I start? Where would I look?
This is actually a very important thing that every citizen, every resident should know. Almost every jurisdiction in Florida, and certainly all of the jurisdictions in Sarasota County, have their local codes and always their zoning codes available online, either by going to the local government's website, Sarasota County if you're in the county, the city of Sarasota, Longboat Key, Venice, or Northport. You go to their website and there'll be links. It may require some looking to their codes, or you can go to a site that aggregates almost all of them. It's called Municode, MUNICODE.com. It's on the web, and I think all of the local governments in our area publish their codes and their zoning codes through Municode, so you can get to it on the website.
So when I came home and I found this notice on my front door, I can just go to municodes.com and I don't have to worry about code enforcement any longer? Probably not. What should I do if I receive this initial notice from the code enforcement department?
I think the most important thing that anybody can do if you get a notice, and it may be take the form of a warning, that's if they're going to give you a citation, or what's called a notice of violation. That's giving you time where if you don't cure the violation, you'll be brought in front of a magistrate or the code enforcement board. When you get that, there's going to be a brief description of the code that you're alleged to have violated, the nature of the violation, and what you're supposed to do to fix it. One of the most common problems that people run into is, one, not responding, because they don't realize that it could actually have some serious consequences. Or two, making assumptions about really what the problem is or what needs to be done. So for just about anybody, I would say the first thing you do is you find the name of the code enforcement officer, which will be on that notice, and usually their phone number is on there, and you call them up and talk to that code enforcement officer about specifically what's the ordinance, is it that the officer thinks you violated, what's the nature of that violation, and specifically what does that officer think you need to do to fix it and to come into compliance. Because there's nothing worse than making an assumption about one of those things and then finding out that you're wrong and getting fined as a result.
I remember that when I received my code enforcement warning, it was because we had an unenclosed carport and they didn't like the condition of the items inside of the carport. But just for purposes of our viewers, what are some other common examples of things that you might get warned or cited for by code enforcement?
The most common things are what's called outdoor storage. Yes, you've got your grill and some other kinds of stuff that it's in your carport, which if it were in your garage, it'd be fine, but if it's in your carport, it can be a problem. Your leaves your grass growing too high, or other kinds of things with the state of the property. Those are the most common things when you look out at the scope of ordinances. Other things that can be a problem are property condition things, torn screens, broken windows, peeling paint, those kinds of things. And what's interesting is that these are usually violations of what's called the property maintenance code. And it can be tricky because, for example, in the city of Sarasota, they've adopted a international property maintenance code by reference, and you can find it. If you went to Muni Code, you go into the building code provisions, and you'll see that they've adopted it by reference, but the text of it is not online. You'd have to go down to the city to see it. And again, there you would see that all of those kinds of conditions are violations, but you couldn't find that online, which again is why it's important to call the code enforcement officer. But yes, building conditions, your yard's not being mowed, and outdoor storage are probably the most common things. Problems with cars not having tags, current tags, or being parked in the wrong place are other common things that will lead to citations.
Now, Robert, I'm mad because I got one of these notices on my door. And is this just a money-making racket, or is code enforcement more interested in compliance ultimately? What's your opinion?
Every code enforcement authority will tell you that their biggest interest is getting people to comply. And let me go a little bit more into the usual process. The usual process is that the notice of violation will give you a certain amount of time to fix it. If you don't fix it within that time, to the code enforcement officer's satisfaction, you'll get a notice of a hearing. Right before the hearing, they'll inspect again. But the hearing is going to be to determine whether the conditions on your property constitute a violation of the ordinance. And this is where a lot of people show up thinking that I can just get more time. I can argue with them to say that they're simply wrong. I can argue to say that it's somebody else's fault, or that the code just isn't fair. Those things may be true. They're often losing arguments at a code enforcement hearing. And the problem is, at that point, they're going to issue you an order that says, now, if you don't clean it up within some period of time, which may be just a day, we're going to start fining you. And if you don't appeal that order within 30 days, your opportunity to do so goes away. So it's important to stay on top of these things. Make sure that you're not going to go to a hearing if possible, but if you are going to have to go to a hearing, show up prepared.
Well, Robert, when we come back, we'll discuss code enforcement hearings and the appellate process. So please stay with us for more Law and Sarasota. And we'll just... Welcome back to Law in Sarasota. I'm your host, Adam Tebrugge, and today I'm joined by Robert Lincoln, and we're discussing code enforcement. So Robert, we were talking about my situation. I came home, there was a notice on my door. You recommended that I called the code enforcement officer. I did that, but I'm just not in agreement with what that officer told me. I think my property's in compliance, and I'm not sure that this code applies to me anyway. Should I consider consulting an attorney about this?
Absolutely. What's going to happen is, as we said, if you can't come to an agreement with the code enforcement officer about what's necessary to bring your property into compliance, the second stage is there's going to be a hearing in front of a code enforcement board or a code enforcement special magistrate. At that hearing, it is an informal trial, and the facts that come out at that hearing are going to be binding on you pretty much forever. The law has got to be argued, and if you have a dispute, if you think that they're interpreting the code the wrong way, if you think that that the code is improper or unconstitutional, any problem that you have with it has to be raised at that point, or you're going to lose it forever. So if you can't come to an agreement with the code enforcement officer about how you're going to come into compliance prior to the hearing, then you definitely should consider talking to an attorney about it, because it's very easy to then waive your rights, not be able to protect them later.
Robert, you mentioned a code enforcement board. Who sits on a code enforcement board typically, and what does this board do?
If you can either have a board. If there's a code enforcement board, it's going to be either 5 to 7 people appointed by the local government, and usually with an attorney to advise them, and they conduct hearings. They set up. Evidence is presented first by the code enforcement officer and then by the property owner or resident who's defending it, and they sit as judges, and they're going to both interpret the law and find facts. At the end of that initial hearing, they will determine whether or not, based on the evidence, they believe that your property is in violation, and those facts will then stick and follow the situation on forward. So they have a lot of power. If there's a special magistrate, it's one person who will be an attorney who's appointed, and again, they act like an informal judge.
You've mentioned evidence a couple of times. Am I allowed to present evidence at this code enforcement hearing? And if so, what kind of evidence might I be getting together?
Absolutely. And one of the things about a code enforcement hearing is that the rules of evidence aren't like what we have to deal with when we're in formal court in front of a judge. So anything that might be relevant, that's a document or a picture, maybe you could bring in and show them. In some cases, for example, they may have decided that there's a condition on the property that's a violation, that was built without a proper permit or built in encroaching in a setback or something, but that's actually been there for years. And if you can have documentation that was there when you bought the property, that hasn't been changed, you should have that. So things like a survey, if you got one when you bought your property, photographs that you may have of the property, all of these things are evidence. All of these things you'll have a chance to put in front of that the board or the special magistrate.
Now, Robert, let's say that we're at the hearing and I've retained an attorney to represent me, and we've presented evidence, but things aren't going so well at the hearing. It looks like the code enforcement board is going to rule against me. What might that ruling look like? What kind of powers does this code enforcement board have?
Well, at this first hearing, which is the violation hearing, as I call it, they're going to be determining whether or not they believe the facts establish that there's a violation. Let's just say that the code that they think is being violated is one that says you've got to keep your grass trimmed. And and there's usually a standard in there that says you can't allow the grass to get above 10 or 12 inches. They have to find, as a matter of fact, that the grass is 10 or 12 inches higher on your property. If they do that, they're going to issue an order that has, quote, findings of facts and conclusions of law. And the conclusion of law will be something like, this provision of the county code applied, and based on the following facts, there's a violation. And the facts are, on this date, the code enforcement officer went in and gave them a notice on this date and found that the grass was too high. He measured it again on this date. He measured on this date immediately before the hearing. There was no testimony that the grass had been cut between the last inspection and the time of the hearing. And so we find that the grass is over 12 inches high and it's a violation.
Then what happens after that? After there's a violation, so what?
Well, the rest of that order is going to say you have X number of days to come into compliance by doing, and usually they recite what was in that original notice of violation, or fines will begin to accrue. And what happens is that unless there's something that's really a giant health problem, these boards usually meet twice a month or once or twice a month. And what will happen is they'll say you have 8-10 days to fix this, or 2 weeks to fix this, or 30 days to fix this. And if you don't, we're going to establish fines. They're going to start. Then there'll be what's called a fining hearing. And so what will happen is at the next hearing of that board or master, they're going to come in, and if the evidence is that no, you didn't take the action that was specified, then they're going to make a finding, okay, the violation hasn't been cured, and therefore a fine of whatever amount they decide is now going to be levied and start running against the property. A couple of things. First, there's 2 hearings, and it's very easy to think that, oh, my time to appeal it will be after the second hearing. But if you don't appeal within 30 days of that first hearing and that first decision, you've lost your right to appeal any of the issues that would have come up at that first hearing. And some of those can be that they didn't give you the adequate notice, there wasn't enough evidence, they didn't follow their own procedures. There's a number of things that could have gone wrong at that hearing, but if you don't appeal it within 30 days, it's gone forever. Once that second hearing takes place, if they find that the violation was not cured, an order will be entered saying, okay, the fines are already at $200, $500, it could be whatever, and they're going to accrue now at $50, $100, $150, $250, $500 a day from here on out. When that order is issued and recorded with the clerk, they record it in the public records, and it becomes a lien on the property. So it gets recorded. Not only that, but under the statutes, once there's an outstanding code enforcement violation, if you go to sell the property, you're required absolutely to disclose it, and as well as any, if there's been a fine or a lien. So again, at that point, it can be fairly serious.
Can code enforcement ever step in and make the repairs to a non-compliant property? For instance, I think we've all seen some derelict houses in our neighborhoods these days, and you sort of wish that code enforcement would come through and fix things up. What about that?
Absolutely. There's a provision that says, in 2 different cases, one, if they actually have an ordinance that says, under these circumstances, we're going to come in and mow the lot. We're going to come in and make repairs. And the statute provides that if a condition on property would constitute a threat to health, safety, welfare, something's falling down, something's been burned, that they can have an emergency hearing, an emergency order, come in and do the repairs. And the cost of all those repairs, the cost of mowing the lawn, the cost of fixing something, again, becomes a lien against the property.
Robert, a few years back, you were involved in a case that got a considerable amount of attention that involved code enforcement issues. Are you able to give us a brief synopsis of that case?
Yeah, and this is again one of the things that it's a good warning story. There was a woman represented who was in Northport who had a situation where she had a car and it wasn't working well, and her church gave her a new car. When the church gave her a new car, she transferred the tag to the new car, and she got a code enforcement officer noticed this, and the car was outside the garage, the old car, without a tag, and he wrote her up for that because it's a violation of the code. Now, here's one of the things that became a problem. She didn't see it right away, and there was a number of things that went on, but even when she found out and called about it, the response was to fix it was get the car off the property. Well, it didn't tell her that she also could have put it in the garage, which would have been a quick fix. Well, she started working with the church that had given her the other car to get the first car towed away, and eventually that happened. But in the meantime, there'd been she didn't go to the hearing. She was found in violation because the car hadn't been moved, and several months later there was another hearing, and the fine hearing occurred, and the car still hadn't been moved, and fines started running on her property. Well, when she finally moved the car, again, because she hadn't been at the other hearings, she didn't realize that they were expecting her to notify them when the car was gone. Well, she didn't, and even though the car was gone, the city kept racking fines up, and the city eventually tried to create a foreclosure against her house, or to reduce the fine to a judgment that they could try to collect against her property. Now, I think this was a bad policy on Northport's part. I think they had a belief that somehow they could get people to pay. What we were able to do in court was establish that the city could not levy the fines longer than up to that second hearing, and we got the judge to hold that and eventually settled with the city.
And that was some very good work on your part. I know that you were recognized for your service to the woman, and I think a service to the community. Robert, if people have further questions about code enforcement or land use in general, what number could people reach you at iCard Merrill?
Our phone number is 941-366-8100. We're also on the web at www.icardmerrill.com, ICARDMERRILL.com.
Well, Robert, iCard Merrill is lucky to have you with their law firm, and I was lucky to have you as a guest today on Law in Sarasota, so thank you so much for joining me.
It's been a pleasure.
And thank you for watching another episode of Law in Sarasota.